All right, good evening, everyone. I am going to call this meeting to order. This is the July 24th, 2024 meeting of the City of Pasco Hearing Examiner. My name is Andy Kottkamp, and I've been appointed by the City of Pasco to serve as the Land Use Hearing Examiner. My job is to render decisions on various applications that are authorized to come before me. What I'm going to do now is just briefly go through a little bit of information about the hearing process before we turn to the agenda. The hearing process has certain rules, but I will conduct the meeting in a relaxed and informal manner, but we still have a procedure we're going to use. For the items on today's agenda, staff will present their report and make whatever recommendations that they wish to make. Then the applicant or the applicant's representative who has the burden of proof will be given an opportunity to testify. And then if there's any public that wish to testify, they'll be given a chance to do so as well. If you are going to testify, I'll have you come on up to the podium there in the hearing room. I'll have you state your name and your address. If you're going to give evidence, I will swear you in as a witness. I'd ask that you keep your testimony relevant to the application we're talking about and not to other issues beyond the scope of the proposal. I have the option to keep the record open on the matters we hear tonight if I think there's a need for additional written testimony to be submitted. But in any event, my written decision will be made within 10 working days after we close the public record. Except as provided by the Pasco Municipal Code regarding requests for reconsideration, my decision on the preliminary plat application tonight, that decision will be final and conclusive unless it is appealed. Appeals are by means of a land use petition action. They have to be filed with Franklin County Superior Court within 21 days of the date of the issuance of my decision, or the appeal would be barred. Now, on the zone change application, I make a recommended decision to City Council. So my decision is not appealable. City Council will then take this matter up. They'll make the final decision. They do it at what's called a closed record public hearing, so there's no additional public testimony that will be heard at that time. City Council will just have the opportunity to review my recommendation as well as all the evidence that was admitted into the record, and then they will make their own independent decision. I've reviewed all the items on today's agenda. I don't have any interest in any of the properties or the proposals to be heard today, and I will be able to fairly and objectively consider each item on today's agenda. Outside of receiving and reviewing the staff report for each item, along with all the attachments to the staff report, which generally include application materials, agency and public comments, noticing documents, basically the entire planning staff file, I've not had any communication regarding any of the items that are on today's agenda. So with those representations, if there is anybody here today who objects to my participation as a hearing examiner, if so, you need to go to the front of the hearing room and state so at this time. I'm not seeing any movement. We'll turn to a couple of items at the same time on this agenda. So I received a request on the first two items on today's agenda, APPL 2023001, APPL 2023-002. I received a request from the city to continue these matters. I assume the Ms. Foster is here by the city on behalf of the city. Did you wish to make that request on the record here today?
Thank you, Mr. Examiner. While the city did earlier request a continuance after further discussions between myself and the city's willing to move forward on the appeal hearing tonight. We don't see a need for a continuance.
Okay. All right. Well, we'll take those up in a little bit. We'll drop to the bottom of the agenda. I want to get these out of the way right away, too. There's PP 2022-003. Preliminary plat 2022-006 and preliminary plat 2022-007. Just in case there's anybody here from the public that's came to testify on this matter, there has been an appeal filed against the SEPA determination for these items, and that appeal basically will stay these hearings until we can have a joint hearing on each of the items. The hearings on those three items are going to be stricken from today's agenda, and they will be then each separately scheduled for a pre-hearing conference. And at that pre-hearing conference, One of the things that will be determined is when the joint hearing for the SEPA appeal and this underlying preliminary plat request, when that joint hearing is going to be held. So if anybody came for the Kimmie Estates matter, Glacier Park matter, or not Kimmie Estates, the Glacier Park matter, Raven Place matter, or Madison Park matter, there won't be a hearing on those items tonight, and you're welcome to stay, but there won't be any testimony provided on those items. All right, so I guess we will go back to the start of the agenda, APPL 2023-001. Pull up my file here again. This is an appeal that has been filed regarding a short plat decision that was made by the city of Pasco. And an appeal has been filed. For the record, I'm going to admit into the record the staff report, all those documents referenced within the staff report, all of the documents from the short plat file, the appeal information that's been submitted by the appellant, as well as a memorandum that was filed 2 days ago, July 22nd, 2024, by an attorney for the appellant. I want to take these matters separately. However, if the argument for the appellant or the city is basically the same on the Sandhu matter as it is going to be here on the Sickle matter, you can simply just say I'm going to restate my position, because there are similar appeals, and then we don't have to go through and make you reiterate everything that you've already said. Not knowing that this was going to be going to a hearing, I thought it was going to be a continuance. So the order of this is going to be the appellant first, because the appellant has the burden of proof to show that the city's decision was an error. Then we will have the city present its evidence and case, and then we'll go back to the appellant. There won't be any public testimony on this matter. This is a matter that is an appeal. It's simply the two parties are the appellant and the city, and public testimony is not allowed on this matter or the second item on the agenda. So we'll jump forward. Is the appellant present and ready to proceed? All right.
Jillian Harlington, present on behalf of the appellant.
Once again, could you state your name? We kind of talked over each other.
Jillian Harlington.
Are you going to be providing any evidence today, or just argument based upon what's in the record already?
Just argument based on what's in the record already.
All right. Ms. Harlington, what would you like to tell me?
Well, Mr. Hearing Examiner, I think that this is a fundamental issue with the city of Pasco in determining that there are a number of conditions that are required for this very simple short plat. Obviously, we have raised issues wherein we argue that the city is violating the takings clause of the Constitution, as acknowledged both under federal and state law. It's very clear from established case law that the city has an obligation to evaluate the very specific facts in relation to the short plat and how those facts impact a quote-unquote public problem in the area. The city has simply responded to our appeal, indicating that because statute allows for certain conditions and because local ordinance allows for certain conditions, they have no obligation to do an actual factual investigation and analysis of what public problems there are to fix with regard to this short plat. This proposed short plat is currently just over an acre. The proposed short plat would divide that single parcel into two separate parcels, approximately half an acre in size each. This is not a large housing development. This would turn this parcel into Lot 1 and Lot 2. The city has analyzed the proposed short plat with the expectation that there are going to be several residential units in the future on these lots, which is simply not facts in the record. And as a result, the city has really not analyzed how this addition of one single lot along Argent Road is actually going to substantially impact any specific problem. The essential nexus test, as I provided in my brief, requires the city to identify the public problem, which it has not done, describe how the development, i.e. splitting the single lot into lot 1 and lot 2, impacts that public problem, how the conditions imposed solve the public problem, and proving that there's proportionality between what is required in these conditions and how that proportionality is fair to the owner of the property. Again, we're looking at a very, very, very small parcel of land being split simply into 2 lots. This is not a large housing development. And the city is asking for substantial development for sidewalks to nowhere, curbing that connects to no other curbing, frontage that is inconsistent with frontage of other nearby lots, and establishment of additional sewer lines and utilities that aren't necessary for what's currently being proposed. And again, the response from the city of Pasco has been, well, there's a statute that allows us to do this, and there's an ordinance that allows us to do this, and we're not required to evaluate this any further. And that's simply a very obvious violation of the takings clause. And quite frankly, it makes it very difficult to appeal because there aren't specific findings that the city is making that we're actually able to evaluate and respond to. The city is essentially saying, well, this is how we want to do it. The statute and the local ordinance allow us to do it this way, and completely ignore the fact that the takings clause of the Constitution does not allow statutes or ordinances that violate the takings clause. And so, what we have in both the Sickle and Sandhu matters is a very similar problem where the city wants to have substantial development that really doesn't correlate to any related development in the area. And with that, I'd be happy to respond to the city's presentation.
So, do you have any understanding as to how many dwelling units would be allowed on each of the proposed lots?
There's currently no application for construction on lot 2.
I know that. So, do you know what the zoning standards are and how many dwelling units could be put on each of those proposed lots? If you don't, you don't. That's fine. I was just...
No, and I'm looking over to our surveyor, Dave Ballman, to see if he has that information handy. I do not.
Yeah, well, it's a matter of looking at the zoning and looking at the code. So it's not a big thing. I just wanted to know if you were aware of that.
Mr. Examiner, if I may, this is Director of the Community and Economic Development Department. The land use permits 3 to 6 dwelling units per lot. I'm sorry, per acre in this area.
Thank you, Mr. Gonzalez. All right. And that would all be a matter of the code. It's not a fact or anything along those lines. Ms. Arlington, is there anything further on this matter for the appellant?
Only reserved for rebuttal.
All right, thank you. All right, we'll turn to the city now. What's the city's position?
Yeah, thank you, Mr. Kotkamp. First, there's just really a fundamental problem with the appellant's appeal that kind of...
I'm sorry, could you state your name for the record,
Yeah,
just in case
sorry.
this goes up on appeal?
Sorry, Aziza Foster with Minky Jackson Buyer on behalf of the city of Pasco. As I was mentioning, Mr. Examiner, there's kind of a fundamental problem initially with the appellant's appeal that really hinders your ability, Mr. Examiner, from considering it, which is, as Ms. Harrington pointed out, they're raising constitutional issues. The hearing examiner is a creature of legislature and only has the power delegated to it by the city council. And the city council cannot delegate powers it itself does not have. The city council cannot rule on constitutional issues. They can't say one way or the other whether or not something is or is not constitutional. So therefore, they cannot delegate to you, Mr. Hearing Examiner, the ability to rule on constitutional issues. So whether or not this does or does not violate either the Washington State Takings Clause or the United States Takings Clause, that really is something that the hearing examiner does not have the authority to rule on. Outside of that, this is actually a pretty simple case, Mr. Examiner. The city is doing nothing more than following its own code. Ms. Harrington kept saying that the city says that it's allowed under law to impose these conditions. And while there may be some allowance under, I think she's probably referencing RCW 5817-110, it's actually a requirement of the Pasco Municipal Code. If you look at Pasco Municipal Code 21-15-030, that's where you get the requirement for all developments, including short plats, to be required in certain situations, like the Sandhu situation for right-of-way dedication, or just more generally for frontage improvements. So that's really what we're here for, is do the developers have to comply with the code? Yes. Understandably, it seems as though that the appellants are really raising a constitutional issue with the code itself. They don't really identify whether or not it's a facial or an as-applied challenge, but either way, one, you can't rule on that, Mr. Examiner, and two, it's not a taking. There are multiple different types of takings, as you're well aware, but when it comes to development regulations, in the absence of an actual physical invasion, the appellants need to show that there has been some deprivation of all economically beneficial or productive use of the property. And there's simply an absence of that from the record. Really what this is this is just simply a police power regulation for the city to ensure that there is access. Ms. Harrington brought up that currently, if these frontage improvements in sidewalks are constructed, they would be sidewalks to nowhere, curbs and gutters to nowhere. But the reverse is true as well. If these frontage improvements aren't required or are not constructed and the surrounding areas are further developed, you would have an absence. You'd have a gap of a sidewalk. You'd essentially have, 2 acres, however much that is in frontage, without a sidewalk. And that's kind of the purpose behind these regulations and why the city enacted them, is so that these current lots, they get served by the frontage improvements. And then as the city builds up as well, you make sure that you have a robust transportation and pedestrian system in place. That's really the purpose of those codes. And that actually is from RCW 5817-110, which is that there's requiring adequate provisions for access. And the need for these improvements do arise from the development. If the appellants didn't seek to divide their land, there would be no need for these improvements. The only requirement or need for these improvements comes from the fact that they are subdividing it. The appellants, they cite to some general principles of case law, but provide no real actual argument as to how these specific regulations are takings. It's especially true when it's not even clear in this situation that we're dealing with exactions that would implicate a nexus or a rough proportionality test. As we're here only for Mr. Sickle, just want to point out, the city's not asking for a dedication of anything. You look at what we're requiring, the city is requiring frontage improvements, which would include potentially sidewalks, curbs, gutters, just simple frontage improvements for this development. And then I had a case for you, Mr. Examiner. I seem to have lost it, but it's I'll leave it at that then. It's simply just a requirement of the code. That's all the city is asking you to do, Mr. Examiner, is follow the code. And unless the code is found unconstitutional, which you cannot do, Pasco has to apply the code to all developments, and the hearing examiner has to follow that code. And so that is all the city is asking of the developer in this case, is to comply with the code. As the staff report stated, one of the findings they have to make is that a development will comply with the code. What the developer is asking is to be relieved from those obligations, and that is not proper. And so I will leave it at that unless you have any questions for me, Mr. Examiner.
Do not have any questions. Let me finish my notes here. All right, thank you. On this matter, anything further from the appellant?
Just briefly.
Yes.
Mr. Examiner, I'll concede that you don't have the authority to determine that a statute or an ordinance is unconstitutional and effectively invalidate that statute or that ordinance. But you most certainly have the ability to evaluate whether Pasco has violated the Constitution in seeking to impose these conditions. The idea that Pasco does not have to comply with the United States or the Washington State Constitution in implementing conditions for land use within the city of Pasco is frankly very disturbing. While you most certainly don't have power to determine that for all of the state of Washington, this RCW, or for all of the city of Pasco, this ordinance is unconstitutional, as applied, it's very clearly a violation of the takings clause. There has simply been absolutely no analysis, and the city doesn't even argue that they have attempted to provide an analysis as to why these conditions are not wholly unproportional to the impact that this short plat will have on the community. And that is all I have, unless you have additional questions.
No, I don't. Let me finish my notes here. All right. Thank you very much. I'm going to close the record on APPL 2023-001. I'll have a decision made within the next 10 working days. We're going to turn now to APPL 2023-002. Would the applicant like to have the applicant's arguments provided in the prior hearing matter 2023-001 incorporated into this hearing by reference?
Yes, Mr. Examiner, I don't have anything further. They're very similar issues.
Right. All right, thank you very much. Is city ready to proceed on this matter?
It is, Mr. Examiner.
And are you requesting that your comments and arguments on the prior matter be incorporated into this matter?
I am, Your Honor.
All right. We'll go back to the applicant just real quickly. Is there anything in addition or that's different about Mr. Sandhu's appeal than the prior one that you'd like to point out? I'm sorry.
There are a couple of differences, Mr. Examiner. None of those differences with the conditions require an argument other than the argument that I made in the prior matter.
Okay, thank you very much. I just wanted to give you that opportunity. And the city agree with that position of the appellant?
There is just one point because in the Sandow matter, the city acknowledges that there is a requirement for a right-of-way dedication, and that was not addressed in the Sickle matter. And so the city just wants to highlight that while it is requiring a right-of-way dedication in this matter, it's, as in the staff report states, it's because it's a right-of-way in fronting an arterial, and there are certain right-of-way requirements, how long a right-of-way or how wide a right-of-way has to be in order to be fronting an arterial. And so that's why the city is requiring a right-of-way in that case, which goes back to without the development, there would be no need for the widening of the right-of-way.
All right. Appellant always gets the last word. And is there anything in response to that position, Ms. Harlington, for the appellant?
I think factually, Mr. Examiner, I'd point out that the site for the Sandu appeal, or the Sandu short plat, again, we're going to have an additional right-of-way along a very small piece of frontage with no matching right of way on either side of that parcel. Additionally, just down the road on Argent Road, it leads to a dead end. And so it's simply not, that road doesn't extend any further at this time. And so we would again rely on our prior argument in that the city has not really factually developed why there's a public concern or why these conditions alleviate that public concern in a manner that's proportional to the short plat.
All right, thank you very much. All right, okay, also for APPL 2023-002, I'm going to close the record on this matter as well, and I will have a written decision made within the next 10 working days.
Thank you, Mr. Examiner.
You're welcome. Thank you very much for your presentation. The next item is the rezone. This is Z2024-004. This is a request to rezone from heavy industrial to MU is mixed use zoning relating to property in the city of Pasco. That is more specifically described in the staff report as well as in the application materials. For the record, I will admit into the record that staff report, the application materials, there's site photographs, zoning maps. I'll admit all those items. Indeed, I will admit the entire planning staff file into the record at this time by this reference. And I'll turn this matter over to, I believe, Ms. Ballard for the staff presentation.
Thank you, Mr. Hearing Examiner. Okay, so this is for Z2024-004 Osprey Pointe, I3 Heavy Industrial to MU Mixed Use Rezone request. The proposal is located at 904 East Ainsworth Avenue, which is parcel 112-420-025, 1110 Osprey Point Boulevard, which is parcel 112-420-026, and 1740 East Dock Street, parcel 112-420-027. There are parcels C, D, and E of Binding Site Plan 2015-05. They're located southeast of the intersection of South Gray Avenue and East Ainsworth Avenue, and southwest of the intersection of East Dock Street and Southeast Road 18. They're currently zoned I3 Heavy Industrial, and these parcels combined have a size of approximately 54.09 acres. The applicant has proposed this rezone of these three parcels from I3 Heavy Industrial to MU Mixed Use to be in compliance with the comprehensive plan underlying future land use designation, which is mixed residential commercial, which I3 zoning is not in compliance with, but mixed use zoning is. And in the future, hope to develop the property with a mixed use development per Pasco Municipal Code, Chapter 25-127, which specifically addresses Osprey Point development. Public notice for this hearing was sent to property owners within 300 feet of this site on July 2nd, 2024, and published in the Tri-City Herald on July 7th, 2024. These parcels were annexed into the city in 1994 from Franklin County under Ordinance 3033 and assigned a zoning of I3 by adopting Resolution 2122. The mixed residential commercial land use designation allows for zoning of R1, R2, R3, R4, C1, O, and waterfront zoning. And under Ordinance 4668, waterfront zoning, the term waterfront was replaced in the Pasco Municipal Code with mixed use. So that's why mixed use zoning, even though it's not mentioned in the comp plan, is compliant with the comprehensive plan future land use designation. Just so to wrap it up, staff recommends that 904 East Ainsworth Avenue, 110 1110 Osprey Point Boulevard and 1740 East Dock Street, Franklin County parcels 112-420-025, 026, and 027 be rezoned from I3 heavy industrial to MU mixed use.
Thank you very much. Is the applicant present today? Good evening, sir. I'll have you state your name and address for me, please.
James Sexton, JMS Development Construction, 904 East Ainsworth, Pasco.
What's your last name again, sir?
Sexton, Sexton.
Got it. All right, I'll have you raise your right hand for me, please. Sir, do you swear or affirm under penalty of perjury that any testimony you give today will be the truth?
True, yes.
Yep. Okay, and you're here as an agent authorized to appear and speak on behalf of the applicant and property owner, is that correct?
Yes.
All right. You had a chance to review the staff report?
I have been in, yes, let's just say yes.
Okay. Do you have any objection to any of the representations in the staff report or anything Ms. Ballard said?
No.
All right. What else would you like to tell me about this request?
It is just one of the steps that will be coming to make a mixed-use great development in the city of Pasco. So with this as being the first step, then we'll go into the rest of them and make a nice waterfront district.
All right. Well, thank you very much. If there's
Thank
nothing
you.
else, I'll turn it over to the public. Did any member of the public come to testify on this matter? I don't see any movement. Is there anything further from staff?
No, sir.
All right. Then, Mr. Sexton, what I'm going to do is I am going to close the public record portion of this hearing. I will have my recommended decision made within the next 10 working days. The last item on today's agenda is also a preliminary plat application.
Thank you.
Application PP, you're welcome. PP 2024 -004. And this is the Kimmie Estates preliminary plat request. And I will turn this matter over to Mr. Hattori for the staff. Oh, I will admit into the record the staff report, the application materials, all the comments that have come through, all the noticing documents, all the site photographs and site plans. I'll admit all those items. Indeed, I'll admit the entire planning staff file into the record at this time on this reference, and now turn this matter over to Mr. Hattori.
Thank you, Mr. Examiner. Yes, for the record, this is PP standing for Preliminary Plat 2024-004, the Kimmie Estates subdivision. The proposal is located on Franklin County parcel 119-512-299, generally located on the south side of West Henry Street between Road 42 and Road 44 in Pasco, Washington. The property is zoned R1, low density residential, and the site is approximately 2.22 acres in size. The applicant wishes to subdivide a single parcel into 11 individual lots and construct or expand roadways and associated improvements. Public notice of this hearing was sent to property owners within 300 feet of the property and published in the Tri-City Herald on July 7th, 2024. The site was rezoned in 2024 under Ordinance 4707 from RS12 Residential Suburban to R1 Low Density Residential in preparation for development. The underlying future land use designation for the site and the surrounding residential properties is low density residential, which allows these lands to be developed with a variety of residential housing at a density of 3 to 6 dwelling units per acre. The proposal is for a density of approximately 4.95 dwelling units per acre. This proposal contains a variety of lot sizes ranging from approximately 5,000 square feet to 10,000 square feet, and 10 of the lots will be located on a proposed cul-de-sac, with the remaining lot located on the west side of Henry Street, the west side of West Henry Street, west of the cul-de-sac entrance. The subject site is constrained by existing residential development and a public park. A through road is not feasible, and a cul-de-sac is sufficient to meet the intent of Pasco municipal codes. A pedestrian access easement is proposed between lots 6 and 7 at the south end of the cul-de-sac, bulb to provide a bike pedestrian connection to the existing public park to the south of the parcel. The site is currently undeveloped, and traffic park and school impact fees will be collected for each lot prior to issuance of any building permit or certificate of occupancy for a dwelling. With that being said, staff recommends approval of an 11-lot preliminary plat located on Franklin County parcel 119-512-299 with conditions and design as detailed in the July 24th staff report.
All right, thank you very much. Is the applicant ready to proceed? Good evening. I'll have you state your name and address for me, please.
Robert McLeod with Knudsen Engineering. Address is 5401 Ridgeline Drive, Suite 160 in Kennewick, Washington.
And Mr. McLeod, can you spell your last name for me?
McLeod.
All right, sir, I'll have you raise your right hand for me, please. Do you swear or affirm under penalty of perjury that any testimony you give today will be the truth?
Yes, I do.
All right, thank you. And sir, you're here as an agent authorized to appear and speak on behalf of the applicant and property owner, is that correct?
Yes, that is correct.
And have you had a chance to look at the staff report?
I have.
Do you have any disagreement with any of the representations within the staff report?
I do not. I'd like to thank Andrew for doing a good job on the presentation.
And have you had a chance to look at the proposed conditions of approval? And if so, do you have any objection to any of those?
We have had a chance, and we are accepting of all the conditions of approval, including the utilities and frontage improvements.
All right, thank you. So with that out of the way, Mr. McLeod, what else would you like to tell me about this project?
I do think Andrew did a good job, but it's intended for single-family residential homes. And it's an optimal location for a development of this nature, as it matches nearby land usages and is adjacent to a public park, as Andrew mentioned. We are providing a pedestrian access easement so residents at this subdivision can access that park easily. And our intention is to develop this property per City of Pasco code, zoning, and municipal, and there's no variances applicable here.
So each lot can be developed without the need for any kind of a variance, is that fair to say?
Yes, that is correct.
Anything else you'd like to add?
Not at this time, thank you.
Okay, thank you very much. I will turn it over to the public now. I saw some folks there. Did any member of the public come to testify on this matter?
It does not appear so, Mr. Examiner.
All right, thank you. Is there anything further from staff?
No, sir.
All right. With that, then, I am going to close the public record portion of the hearing. And I'll have a decision made within the next 10 working days. I don't see anything else on the agenda. Is that correct, Mr. Hattori?
Mr. Examiner, no, other than the preliminary plats that were discussed earlier in the meeting.
Yeah, okay. I just wanted to make sure of that, because I saw people in the hearing room and I wanted to make sure that maybe I didn't get an updated agenda. But those items, as I stated at the beginning, PP 2022-003, PP 22-006, and PP 22-007, those items were stricken from the agenda at the beginning tonight. And I will be setting up pre-hearing conferences for those, for the SEPA appeal, along with the combined combined hearing on the underlying matter. So, were there any questions on that, Mr.
Mr. Examiner,
from staff?
no questions from staff, but I do want to make note that there are several representatives from the applicants on the application teams of those preliminary plats. I don't know if it's an opportunity for them to provide or ask any questions of you about the process moving forward, but I did want to make that make you aware of their attendance in the meeting this evening.
All right. Well, what I'm just going to do is just tell you, you don't have to come up and ask a question. We're not going to have any hearing tonight. There's not going to be any presentation of evidence. What's going to happen is If you are represented by an attorney and the city's represented by an attorney and the applicant and the appellant, then once all those determinations are made, then staff will coordinate with me to set up a pre-hearing conference for each of those items. They're all going to be separate hearings, even though it's the same appellant. We're not going to combine them all into one great big matter. They're all going to be taken care of separately. And at that pre-hearing conference, then we will set a schedule for disclosure of witnesses, disclosure of exhibits, disclosure of briefing, and then we will also set the hearing dates at that time. I wouldn't anticipate. I have, no understanding about how the appellants are going to want to proceed in this matter, or the applicants, or the city. But we're probably not looking for a hearing date until September or October. So that's what a SEPA appeal will cause, that kind of a delay as we get prepared for that process. So, Mr. Gonzalez, did I explain it at least as adequately enough for city staff?
You sure did. We appreciate it.
All right, you're welcome. Okay, well, we'll be in touch on this matter soon enough. There are no other items on today's agenda. I'm now going to adjourn this July 24, 2024 meeting of the City of Pasco Hearing Examiner. Thank you all very much for coming out tonight. This meeting's adjourned.